A lot of people online are saying that the Old Dominion University shooter should have been deported a long time ago. The problem is, if the facts are what they appear to be, the law never allowed for that in the first place. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. Today, a tragic shooting at Old Dominion University is being discussed across the country, as it should. An Army ROTC instructor, Lieutenant Colonel Brandon Shaw, was killed in what authorities are investigating as a terrorist attack. Reports indicate that the shooter had previous interactions with ISIS and had previously been prosecuted for ISIS-related activity. That fact has triggered a wave of commentary online asking a familiar question. Why wasn't this person deported before he had a chance to commit violence? You're already seeing this incident folded into a broader political narrative about immigration and Muslims in America. We've seen this pattern before. When acts of terrorism occur, they often get pulled into existing political arguments about immigration policy and about Muslims more generally. In this case, those two narratives happen to dovetail neatly, which is one of the reasons the story is spreading so quickly in certain political circles, especially within MAGA. But before we jump to any conclusions, it's important to understand something that most commentary leaves out. U.S. immigration law doesn't operate on slogans. It operates on very specific, and in some cases, arcane legal categories. There are several key concepts involved in this situation. One is the concept of inadmissibility, the concept of deportability, and the implications of citizenship and naturalization. For context, I've spent much of my career working in national security and immigration law, including literally decades working on counterterrorism. So let me walk you through how the law actually works here. The first distinction is between inadmissibility and deportability. Think of these two concepts as different checkpoints in immigration law. Inadmissibility applies when someone is trying to enter the United States or obtain some sort of immigration status, like a green card. At that stage, the government can deny entry or deny adjustment for a wide range of reasons. The statutory grounds include things like criminal convictions, fraud or misrepresentation in the immigration process, national security threats, terrorism-related activity, immigration violations, and even certain health issues. If someone falls under a terrorism-related inadmissibility ground, the law is quite clear. They cannot be admitted to the United States. But compare that with deportability. Deportability applies to someone who is already inside the United States with some sort of lawful status. Once a person is admitted, the government must prove that the person falls within a specific statutory ground of removal, and those grounds are a lot narrower. Examples include certain criminal convictions, national security violations, immigration fraud, or violations of the terms of a visa or a green card. So the legal question isn't simply, did this person do something wrong or do something dangerous? The question is, do they fall within a statutory ground of deportability? Now, cases involving terrorism often involve multiple legal systems operating at once. There's criminal law, national security law, which can be criminal in nature, but not always, and immigration law, which is civil. They overlap, but they're not interchangeable. If someone commits a crime connected to a terrorist organization, the government may prosecute that person in federal criminal court. And if they're convicted, they serve a criminal sentence in U.S. prisons. Only after that process do immigration consequences come into play. And those consequences depend entirely on the person's immigration status at the time. If they are a non-citizen, certain convictions can make them deportable. But if they're a U.S. citizen, immigration law generally stops applying. It is completely removed from the equation. And this is the critical point that most online discussions seem to leave out. Once someone becomes a U.S. citizen, the deportation system stops applying to them. With one minor exception, U.S. citizens cannot be deported. That rule exists for a fundamental constitutional reason. Citizenship carries the right to remain in the United States. Once a person naturalizes, they are treated the same as any other American citizen. If they commit crimes, they are prosecuted under criminal law, but not immigration law. So when, like now, people start asking, why wasn't this person deported? The critical question is, what was their immigration status at the time? If the person was a citizen, deportation just simply wasn't an option under the law. Now, the one narrow exception that I mentioned earlier is denaturalization. Denaturalization is the process through which the government strips someone of citizenship, but it only applies in very narrow circumstances, specifically when there was some sort of fraud or illegality involved in the naturalization process. These standards are extremely strict, and for good reason. The government must prove that the person lied or concealed material facts during the naturalization process, or that they obtained citizenship unlawfully in some other way. My former office at the Justice Department, which was the Counterintelligence and Export Control Section, used to be involved in one of the ways where this area of immigration law would intersect with national security law. Rarely, but occasionally, a foreign intelligence officer would enter the United States under non-official cover. If they entered the United States under non-official cover, subsequently naturalized, and then got caught for espionage, that would be a prime example of where the United States would seek denaturalization. But in that instance, it was only possible because there was both fraud and other forms of illegality directly involved in the naturalization process itself. Specifically, the person did not disclose that they were an agent of a foreign power when they applied for naturalization, and they obtained naturalization for the specific purpose of committing espionage. That's kind of a rare and extreme example, but it did happen. But importantly, people who were already U.S. citizens when they started committing espionage could not be denaturalized, however much their crimes directly reflect disloyalty to the United States. Because in those instances, there was no fraud involved in the naturalization process. The espionage only started later. In theory, the same principles could apply to agents of a terrorist organization. For example, hiding your membership in a terrorist organization during the naturalization process could potentially qualify. But even then, the burden of proof is very high. And importantly, denaturalization is not punishment for crimes committed after naturalization. It only applies if the citizenship itself was illegally obtained. When tragedies like this happen, people understandably look for simple explanations, but immigration law rarely offers simple answers. The fact that Donald Trump has represented kicking all the immigrants out as a panacea for all of the nation's problems warrants a whole series of videos unto itself. But the key principles here are relatively straightforward. Inadmissibility determines who can enter the United States. Deportability governs who can be removed from the United States, and citizenship almost always bars deportation. So one of the reasons I spend time explaining these issues is that the intersection of immigration law, national security law, and criminal law is poorly understood, even by legal practitioners within those separate areas of the law. At Charles International Law, we're actually in the process of developing online training programs for legal practitioners who want to better understand these intersections, particularly in the context of counterterrorism and national security cases. And in moments like this, clarity matters.